In the cutthroat political battles which engulf our country, the amendments often feature at the center. One amendment that has seemed curiously absent is the 10th Amendment, though it has definitely appeared as a ghost in the many debates that have taken place. That the 10th Amendment is not as prominent as others in our modern political spars is curious, since it is in fact the amendment that has been the cornerstone of the federally constructed government that the framers created. Originally, the 10th Amendment was seen as the linchpin of the entire Bill of Rights. Since the Federalists, those who fought for the ratification of the Constitution, did not want there to be a Bill of Rights. This was not some plot on the part of the Federalists to impose a bureaucratical leviathan upon the new republic, but was in fact an effort to protect the rights of the people. As Federalists like Alexander Hamilton argued, the Constitution listed the specific enumerated powers that the people bestowed upon the new national government. If the Constitution included a Bill of Rights, then the question became, did the Constitution before the Bill of Rights give the government the ability to infringe upon those rights? When a Bill of Rights was the only means by which the Constitution was assured passage, the 10th Amendment was designed for a twofold purpose. Not only was it created to sustain the Federalist system which the framers designed, but also to ensure that men would not argue that the ability to bridge the freedoms enshrined in the amendments was implied in the Constitution through the apparatus of the 10th Amendment. Unlike so many of the other amendments, the 10th Amendment was not a point of contention for the first 50 years of our nationhood. The only real application of the 10th Amendment, perhaps, in this period, were the Virginia and Kentucky resolutions, which were written by Jefferson and Madison in answer to the Alien and Sedition Acts. In the 19th century, however, the amendment began to be cited by the Supreme Court, especially in support of the dual federalism theory, which maintained that the national government and the state governments were independently sovereign and acted independent in their own spheres, which was contrary to the fact that the framers had intended to create a system of mixed sovereignty, in which the states were seen as an integral part of the new nation. Also in the 19th century, the court began to read the amendment as saying that the Constitution, as it was originally written before the Bill of Rights, did in fact give the government the power to abridge the rights listed in the Bill of Rights. This came about in 3 legal tender cases: Hepburn v. Griswold in 1870, and Knox v. Lee and Parker v. Davis in 1871. Cases that involved the government's Civil War activity of issuing paper money without hard specie backing it. The court came to the decision that the ability to print paper money was not located in any one specific enumerated power, but that it was still a legitimate power of the government, saying, quote, "They tend plainly to show that in the judgment of those who adopted the Constitution, there were powers created by it, neither expressly specified nor deducible from any one specified power, but which grew out of the aggregate of powers conferred upon the government or out of the sovereignty instituted." With the 20th century and the New Deal, the 10th Amendment was often brushed aside. In Wickard v. Filburn, for example, the court in 1942 ruled that Congress could regulate how much wheat a farmer grew on his own field for his own private consumption. This led to a barrage of rulings that led to decisions, quote, "that were not contemplated by the founding generation, such as federal regulation of state government employment relations, federal use of state officials to enforce federal regulatory regimes, direct federal commands to state agencies or legislatures, and extensive control of state policy through conditions on federal spending for states," unquote. All of which depended on very broad interpretations of the Commerce Clause, Spending Clause, and Necessary and Proper Clause. In 1976, the court did indicate that the 10th Amendment still possessed power in National League of Cities v. Usury, in which the court called in the 10th Amendment to prevent state officials from falling under the Federal Fair Labor Standards Act, an act which would have, in the words of Justice William Rehnquist, transgressed on the, quote, "functions essential to a state's separate and independent existence," unquote. In 1985, however, this decision was reversed, in Garcia versus San Antonio Metropolitan Transit Authority. That was still not the end of the jurisprudential discussion, as a series of cases seemed to shy away from the Garcia case. New York versus United States in 1992. For example, the court, quote, prevented Congress from requiring a state legislature either to take care of a problem that Congress did not itself wish to deal with under its own enumerated powers, or to take title to these materials and to be responsible for their safe disposal, the safe disposal of radioactive material. Gregory versus Ashcroft in 1991, in which the court, quote, noted the serious 10th Amendment implications that would be raised by a congressional attempt to regulate the employment of state judges, unquote. And Prince versus United States in 1997, in which the court, quote, banned Congress from requiring state executive officials to implement a federal scheme of firearms regulation, unquote. Today, with the unstopping assault from the federal government on federalism, with the Departments of Education, Energy, Veterans Affairs as 3 examples, and Supreme Court decisions on health care and marriage, the 10th Amendment is in a curious situation of not really being part of the discussion, and yet its shadow has emerged to cover the political landscape. Presidential candidate Ted Cruz invoked the 10th Amendment when Stephen Colbert suggested Cruz was opposed to quote-unquote gay marriage, Cruz saying that if a state wanted to change its marriage laws, then it could. Perhaps by far the most adamant champions of the 10th Amendment have been the 10th Amendment Center, which advocates nullification in response to perceived overreaches by the federal government. The Center champions Jefferson and Madison as the originators of nullification and sees those who, instead of nullification, advocate a convention of the states for the proposal of new amendments to the Constitution, with scorn, saying that such an act could lead to an out-of-control convention where the entire Constitution could be destroyed. In citing Madison, at the very least, however, the Center seems to misrepresent the father of the Constitution, as Madison did not propose nullification, but interposition. And while these 2 terms have been equivocated today, in the Founders' time, interposition referred to the attempt to reverse federal laws that were seen to be unconstitutional. This could involve citizens, groups of citizens, or the state legislatures not acting as sovereign, but as the instruments of the citizens of that state. At the heart of this whole matter is this simple question: what powers are granted to the federal government? If broad and elastic readings of the commerce and necessary and proper clauses are correct, and the government can mandate that all citizens participate in a health care plan, then the 10th Amendment is satisfied, as the federal government has not overreached its limits. But if the federal government is restricted to the specific powers given to it by the Constitution, then the amendment has been violated and must be brought back into play.